This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about the fact that there is no excuse for lying to your insurer, and that if you have claimed but do not have a monitored fire alarm, you have no coverage because breach of a material condition for a monitored fire alarm voids coverage. In Northfield Insurance Company versus Michigan 32 LLC, the United States District Court for the Eastern District of Michigan on September 10, 2025, dealt with the motion from Michigan 32 for reconsideration of the court's opinion and order granting summary judgment to Plaintiff Northfield Insurance Company. The matter arose out of a commercial insurance coverage dispute where Northfield denied MI-32's fire loss claim. The court granted summary judgment in favor of Northfield on its declaratory judgment action. The court held that MI-32's admitted failure to comply with its policy's protective safeguard endorsement, the PSE, requiring that the insured building be protected by a centrally monitored fire alarm, which was a condition precedent to coverage, precluded coverage for the fire loss under the PSE terms of the fire loss exclusion. Second, the policy was void ab initio, where it was issued in reliance on MI-32's undisputed material misrepresentations in its application, that is, that it had an ADT-monitored fire alarm, when its principal later admitted it never did. MI-32 now maintains the court granted Northfield's motion without addressing its waiver and estoppel defenses. The local rules of this district, that is, the Federal District Court in Michigan, no longer allow a party to file a motion for reconsideration of final orders or judgments. Motions to alter or amend judgment pursuant to Rule 59E may be granted only if there is a clear error of law, newly discovered evidence, an intervening change in controlling law, or to prevent manifest injustice. While Rule 59 permits a court to alter or amend a judgment, it may not be used to relitigate old matters or to raise arguments or present evidence that could have been raised prior to the entry of judgment. Rule 60B allows a court to relieve a party from final judgment, order, or proceeding for the following reasons: 1, mistake, inadvertence, surprise, or excusable neglect; 2, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under Rule 59B; 3, fraud, whether previously called intrinsic or extrinsic, misrepresentation or misconduct by an opposing party; 4, the judgment is void; 5, the judgment has been satisfied, released, or discharged. It is based on an earlier judgment that has been reversed or vacated, or applying its prospectively is no longer equitable, or 6, any other reason that justifies relief. In its response to Northfield motion for summary judgment, MI-32 argued that Northfield waived or should be stopped from asserting coverage preclusion or policy rescission because Northfield knew or should have known that MI-32 did not have an automatic fire alarm system. One basis of Northfield's alleged knowledge was an August 25, 2022 phone conversation between MI-32's principal and Travelers Risk Control Consultant Melissa Ellison, characterized by MI-32 as an inspection which took place months after the policy was issued. The court expressly found that MI-32 produced no evidence to contradict the Northfield underwriter's affidavit. attesting to the fact that Northfield did not know there was no automatic fire alarm system at the subject property when it issued the policies, and that would not have issued the policies to MI-32 had it known. The court did not commit clear error of law or manifest injustice, nor is there any basis to conclude that this is an unusual and extreme situation where principles of equity mandate relief. MI-32 fails to satisfy its burden under Rule 59E or 60B and merely rehashes arguments contained in its responsive pleading that were already considered by the court. Defendant's motion for reconsideration or rehearing is therefore denied. In my opinion, the covenant of good faith and fair dealing implied in all insurance contracts applies equally to the insured as it does to the insured. In this case, the insured blatantly lied on its application for insurance that it had a monitored fire alarm system, and after the fire, the insured admitted there was no alarm. The policy could have been rescinded and was for that lie, and the endorsement, a condition precedent to coverage, eliminated the coverage even if the policy wasn't rescinded, and therefore there was no coverage either way. And the motion for reconsideration was a waste of time trying to find some excuse for the insured's lies. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,150 blog posts. You can also subscribe to these videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.